acknowledges how a cardiopulmonary exercise test, known as a CPET, is the gold standard for measuring the functional capacity of a disability insurance policyholder with fibromyalgia, but how a doctor's failure to explain the basis of the claim can doom a claim, notwithstanding the CPET. Now, look, many courts don't require laboratory data to confirm the symptoms of fibromyalgia, such as pain and fatigue. So they don't necessarily look for an objective basis of the diagnosis because there is not always an objective basis, even on physical examination. But the courts do agree that a disability carrier is entitled to have medical evidence of a physical disability that prevents the policyholder from performing the material and substantial duties of their own occupation. And the disability carrier is also entitled to an explanation of how and why the treating physician assigned the restrictions and limitations. But what happens if the treating physician doesn't provide that information? The disability carrier is going to have their own liar-for-hire doctors review the medical records. They're going to have the liar-for-hire doctor reach out to the treating physician for clarification. Now, if the treating doctor doesn't explain the basis of the diagnosis and the physical restrictions and limitations, a court is generally going to agree that the carrier has the legal right to reject that opinion and rely on the opinions of the peer-reviewed doctor. Now, as I've said, one of the most common defenses to a fibromyalgia disability claim is the carrier's argument that there is no objective evidence of the fibromyalgia and there's no objective evidence of the functional restrictions and limitations. And sometimes carriers will take this a step further and have the policyholder undergo a not so independent evaluation by their hand-picked doctor so that they can claim that they have thoroughly evaluated the fibromyalgia claim before denying it. So how does this play out? Well, it doesn't always play out in the favor of a policyholder, but in the case of Medifessor versus MetLife, which is an Oregon case, it does, in part. And let me explain the details of this case. Ms. Medifessor was diagnosed with fibromyalgia. She had all the classic complaints of fibromyalgia: multiple trigger points, body-wide pain, brain fog, decreased energy. She stopped working and she applied for both her short and long-term disability benefits, which were denied by MetLife. She appealed. And as part of her appeal, she underwent a CPET test that measured her capacity for physical activity. The testing revealed that she had a limited threshold for performing even seated sedentary work. So MetLife then had her file reviewed by a rheumatologist who cited the CPET results as objective measures that clearly distinguish between indolence and true disability, and noted that the findings were consistent with her subjective complaints and objective findings on examination. So MetLife accepted that and paid her own occupation benefits. But when the standard of disability changed to any occupation, they exercised their rights to a not-so-independent IME. And MetLife had noted in the medical records that she was her ailing mother's primary caregiver, and MetLife went off to the races. So you need to be careful about what you're telling your doctor. The IME said what the IME was paid to say. She could do full-time sedentary work 8 hours a day. And guess what happened? Her claim got denied. Now, she filed an appeal. That was also denied. And as a result, she ends up in federal court. And she argued three things. One, that MetLife improperly terminated her benefits and denied her claim without evidence of improvement. Two, that the IME improperly required objective data, notwithstanding the results of the CPET. And three, that the CPET report was the gold standard for measuring and evaluating her functional capacity and fatigue. Now, the court threw out the denial, noting that the CPET was considered in the fields of exercise science and medicine as the gold standard, and was recognized by the American College of Sports Medicine, American Heart Association, American College of Chest Physicians, American Thoracic Society, and American Medical Association. They found that the CPET, which is a study that's normally based on 2 exercise tests on consecutive days, was a standardized physical stressor and recognized. Now, the court accepted that, and the court also ultimately accepted her arguments and awarded claims, but the court also criticized her physician for not really addressing why the restrictions and limitations had been assigned. She was fortunate because most courts would have denied the claim and said, we've got to connect the CPET in terms of her restrictions and limitations and her inability to do any occupation. But this court was sympathetic. So while she was awarded the benefits, I think there are a couple lessons here. The first lesson is that every fibromyalgia policyholder should have a CPET exam to document their restrictions and limitations. Secondly, they should have their physician endorse the results of the CPET. 3, they should have their physician explain that the basis of the restrictions and limitations are based not only on their clinical examination of you based on the findings that you present, but that is also consistent with and correlates with the CPET exam. I really don't want the carrier to seize on the argument that there's no explanation for the CPET results and the restrictions and limitations, even though that would be self-evident.